Information Station 1370 WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. Thank you for tuning in this Wednesday morning. It is time for Legally Yours. This is the program hosted by John B. Fuller. He's an attorney here in Ocala at the law firm of Fuller and Fuller. The other Fuller in the name of the law firm is his beautiful wife, Janet. John is here to answer your questions about legal situations you might find yourself in, or maybe somebody in your family, or maybe one of your friends. And just so you know, whether we're live or not, if it's October 23rd, 2013, where you are, then you're listening to a live show, and you're welcome and invited to call. The number is 622-9622, 622-WOCA, and that is a sponsored phone number, so that's why we say it's the WOCA Climate Control Source Hotline. Good morning, John. How you doing?
Good morning, Larry. How are you?
Pretty good.
Good morning to all our listeners. I think we may be getting a touch of fall weather, at least it looks like it.
Does it feel like it out there?
It slightly, yes, and hopefully it'll continue.
I was just going to ask you if we could sue the meteorologist, because I thought he had it wrong.
I think that maybe he was maybe he was just premature.
Can you imagine that? I mean, that would be a frivolous lawsuit, wouldn't it?
That would be. Shooting the messenger is not very productive, and at best they read the tea leaves and come up with their best guess, I think.
Yes, they do. And better now than, I guess, in the past. All right, we have some phone calls coming in, so let me push a couple buttons and take the first one.
Wonderful.
Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller. Always good to hear you.
Good morning. It's nice to hear from you. How are you, sir?
All right. Got a question. Recently, the guy from up in Jacksonville, I guess he was found guilty on, I guess almost 100 charges of racketeering or whatever.
Yes.
That was in charge of this Allied, or I guess the
Internet Cafe.
Internet Cafe. Exactly.
Oh, that one. Oh, that cafe.
Now, what he said was, he said that he's going to appeal this, I guess even all the way up to the Supreme Court, because he says that he was only acting as an attorney and giving legal advice to his clients, and therefore he shouldn't have been found guilty of just giving legal advice. I'm going to hang up and let you kind of give me your impressions on that, I guess, defense. Thank you.
Okay, well, I'll be happy to share with you, like you say, my impressions. I know nothing about the details of the case, so I could not comment on any specific aspect of it. And the information that I do have comes solely from the media. So there's just some kind of general comments that I could make that I think might be somewhat relevant. I saw in this morning's paper that the defendant has filed a motion for a new trial. And one of the major grounds for his motion, which will undoubtedly be the centerpiece of any appeal, is that the trial judge ruled that he could not introduce evidence in the trial so that the jury could be told that at the time he gave the advice concerning the formation of the corporation and the creation of the business organization to run the Internet Cafe, that at the time he gave that legal advice on how to set up that transaction, the government had in place a sophisticated set of regulations that were adopted after the legislation was passed for government to regulate this industry. And the premise, as I understand it, of his defense is you cannot convict a lawyer for advising a client of an activity that government itself recognizes is legal, at least to the extent that it went so far as to create regulations on how to regulate it. And for whatever reason, the judge did not allow that testimony to be heard by the jury. So the jury is not able to listen to the radio or watch television or read a newspaper or get any information other than the evidence that is presented during the trial. So they had no information to weigh that element as to whether or not that mitigated against the accusation that he was somehow involved individually in committing what has now been deemed a crime. His theory is that this would have a chilling effect upon a citizen's right guaranteed by the Constitution under the 6th and 14th Amendment to have effective assistance of counsel to represent them, because no lawyer would want to give advice in an area of the law that may not be crystal clear, but which they are in fact certain regulations that are subject to interpretation, would not provide legal services to that individual for fear that years later some elected prosecutor may seek to prosecute that lawyer. And that is troubling. And back in the 80s, there was I don't know that it was an overt plan, but it was certainly suspicion to be a goal of various prosecutorial entities, especially at the federal level, to go and prosecute lawyers who specialized in defending people who were charged in drug crimes. And they charged these lawyers with a number of criminal offenses back in the 80s. And one of the balancing acts that was put before the court is if you attack the person who is charged with defending a person, how is anybody going to ever be able to have a fair trial if they can't get someone to defend them? And if you are targeting, and I'm not saying that if a lawyer who's representing a client has done something wrong individually, that he should be immune from prosecution because he is no more above the law than any other person. But when they make this a policy, which there was some concerns that was happening, then you end up with a problem. This lawyer, just from what I know of having read about him in the paper, was highly respected in Jacksonville. He had been president of the Jacksonville Bar Association, or the Duval County Bar Association. He had the highest rating for both legal ability and legal ethics that can be conferred by the national rating system of Martindale-Hubbell, which rates all lawyers in the country based upon peer confidential interviews with other lawyers and judges in the jurisdiction. He had been given countless number of awards for service to the Florida bar. He was someone who was held in high esteem and highly respected in his community and in his profession. It's a very unusual case, and it will be interesting to see how it plays out. They charged him with over 100 counts, so it that sounds terrible, but they are offenses that are simply the same base alleged offense, and they allege it for every entity or other things that you can have a multiplier. For instance, there are laws on the books that says that if your water retention area in your homeowners association is not in compliance with the regulations of the St. John's Water Regional Management Center, that they can fine you, that every day that it's out of compliance is a separate offense for which they can can fine you X amount of dollars a day. And so if your water retention system doesn't comply for 2 years, they could theoretically charge you with an offense for every day it's out of compliance. So don't be overly swayed by the fact that, well, where there's smoke, there's fire, and if this guy got charged with 100 counts, there may be something there. There could be one basic allegation that that was the seminal charge, if you will, and they just tacked it on for each entity that was operating or something like that. Again, I know none of the details of the case. I appreciate the caller, as I do every week. Our callers have wonderful questions that are always relevant and up to the minute, and these are appropriate legal questions to have. You can't know what the details of a case really are unless you are there in the courtroom every day and hear all of the evidence and all of the rulings of law by the judge. You really aren't in a position to make any knowing or educated opinion or decision.
Wow. That was great. The phone number here is 622-9622 if you'd like to speak to John. There was a story this morning, if you don't mind me. Can I just read it to you a little bit?
Yeah, sure.
A Westchester County, New York man, and this is in the city of Pelham Manor. This is yesterday's news. He cannot enter parts of his house without risking arrest because it sits across the property line. Part of the home of retired New York Police Department officer William Cullen was ruled to be 3 feet over property line of the neighboring house owned by the wife of former New York Jets guard Sam DeLuca, who died in 2011. A stone divider served as a boundary between the houses for years, apparently unquestioned, when a previous owner of Cullen's home built an addition in the late 1930s. A subsequent survey indicated that it was actually 3 feet over the line, which was drawn in 1908. The judge drew a line through my house and said, "You don't own this part of the house," Cullen said after the court case earlier this year. "It's my house. I can't even do any repairs on it. If I got out and did something, I'd be arrested." What are your thoughts on that? I mean,
well, that's very interesting. I've not read that. I don't know anything about it, and it's not under Florida law, so there's not a whole lot I can say. Encroachment cases one of the remedies that a property owner has, if another property owner adjacent to him or her builds a structure that encroaches upon the other person's property without their permission, and it does not ripen into ownership by some theory known as adverse possession, which is another legal theory, and we'll get into it maybe in another time. But if there's no legal theory where he could claim ownership by adverse possession, then it would constitute a trespass. It would constitute a continuing trespass. And
wow.
I think that is unfortunate that it rose to that level. There's a saying in the law, Larry, that bad cases with bad facts make bad law, and I think that's a good example of it.
Yeah.
That's an example where reasonable people should have said, "Look, all right, a mistake was made.
Right.
If the addition to the house and the encroachment was not demonstrably interfering with the other person's property, then there should have been some kind of a monetary workout where you say, look, we'll have this appraised. I will pay you for the cost of the property that has been taken by this encroachment. I will pay you remainder damages for any damages that you've may suffered by the diminution in the size of your remaining property," and treated it in that fashion. That would have been too easy, I guess, when people feel strongly about things. I had a trial 25 years ago where two landowners who own thousands of acres of land each were fighting over a boundary line that was about 30 to 40 feet in dispute, and we ended up going to court and getting an injunction to prevent them from having any contact or coming within a certain number of feet until that trial was disposed of, because both of them had shotguns and were out there.
Oh, wow.
And the law enforcement officers were called on several occasions because these people had very hostile relationships, and they were both out there with their shotguns.
Oh, my
So
goodness.
we obtained an injunction, and then we had a trial, and that was not, and that was based upon conflicting interpretations of surveys. And fortunately, we prevailed because our surveyor was able to go back to the old field notes of the original government survey when Florida became a state, and found how they interpreted what is known as an oversized section of land. And so we prevailed. And what I told my client, and the lawyer on the other side told his client, is that, hey, this is there is no structure on this. This is a piece of pasture land. It's about 40 feet. Why don't we divide it down the middle? You take 20, the other side take 20,
that makes sense.
and share the cost of the survey, do reciprocal deeds to clear up the legal description, and go about your way. And nobody wanted to do that, and they spent thousands and thousands of dollars on lawyers and surveyors over 40 feet of land, and then it was all over. The winner actually said, well, that's a lot more money than that property's worth. And fortunately, I had a letter that reminded him and her, the wife, that there was going to be an awful lot of expense that would exceed the value of the 40 feet they were fighting over. It was a matter of principle then. And principle is not always a very good reason to justify a lawsuit.
No. And it looks like you have another phone call. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller.
Good morning, sir. How are you?
Very good, thank you. If a person is planning on going in for surgery and the physician would like you to sign a document for liability, do you have to sign that? And if you don't, can a physician refuse his services to you?
I don't want to answer as to a specific situation. Generally, the law says that you cannot contract away professional negligence. If a professional is going to undertake a professional task, the law is going to require him to perform that task with a standard that meets the standard of care for that procedure by that specialty in this community, and you cannot contract away that liability. The professional can seek the waiver, if you will, or release. And if you choose not to sign it, there is no law that says he has to treat you, he or she has to treat you or perform the procedure, so they certainly could decline to accept you as a patient. I really don't know of any specific case right on point where one of those releases have ever been litigated, but as a general principle, you cannot contract away professional negligence. In other words, if you had someone sign a release that you released that professional from any damages that might occur as a result of the surgery, and you had simply a bad result that could have happened to under any circumstances, because nothing is perfect and no one is able to offer a guarantee, and there are known complications to every medical or surgical procedure. So that may have some bearing in a case like that. If it's another situation, and I'm making an egregious hypothetical here simply for the purpose of example, if the physician gets one of those releases signed, and then he shows up at the operating room drunk, and you were supposed to have your right leg amputated, and he amputated your left leg, and then when you determined that you had been the victim of a serious breach of the standard of care, and he waives this piece of paper, I do not believe that he should take much aid or comfort that that paper would protect him for the damages that he caused in an example like that. I hope that helps to show the extreme ends of both sides of this, and I don't know where the exact middle answer is.
Yeah, interesting. You know, every once in a while you read or hear about a person that has some kind of an instrument that was sewed in him after surgery, and 2 years later, after a lot of misery, they go back and find out that there's a knife there or scissors or whatever. I don't know if the doctor would be liable or the hospital or whoever, but would you be protected with that situation?
There is a statute in Florida that makes it a presumption that it is negligence and breaches the standard of care if a foreign body is left inside the patient. So you don't even have to prove negligence if you establish that there is a sponge or a hemostat or some foreign body that should not have been left there. If you prove that that is left in the body, and you don't discover it, the statute of limitations in professional malpractice cases does not begin in Florida, and they're different in other states. But in Florida, that's the statute of limitations does not start to run until the patient knows or should have known that they have suffered some damages as a result of medical negligence. A lot of times the things won't develop symptoms for a period of time, and you don't know that the sponge is there for maybe 6 months.
Oh, wow. And you have another phone call. Good morning. You're on there with John Fuller.
Good morning.
Good morning. How are you?
Hi, Larry. This is Kathy.
Hi, Kat. How are you?
I have a question. Is there any legal recourse for an overzealous use of the HIPAA law?
I'm not sure, Kathy, I understand the question. The HIPAA law is a law that ensures confidentiality in medical records and prevents medical providers from disclosing or sharing medical records of a patient with any third party without the written consent of the patient or some other court order. So I don't know.
Give the example I've got then, real quickly, okay?
Okay.
It's a vet that it was regularly calling on a fellow vet, and the person was placed from the hospital into hospice. And the vet that's been his friend and been visited does not
when you say, excuse me, when you say vet, are you talking about a veteran?
A veteran.
Not a veterinarian?
A veteran.
Okay.
Yeah. The veteran does not know which of the 4 hospices, or 5, I don't know how many we have, his friend has been placed, and the hospice will not disclose if he's even there.
Right. Unfortunately, that is not, in my judgment, an overzealous application of HIPAA. They are bound by this law. It is a very, very restrictive, stringent law, and I think the medical provider, hospice, or whomever are duty-bound not to give out that information. They are people who value their privacy and absolutely under no circumstances want anybody to know that they are in any healthcare treatment facility, and most especially an end-of-care treatment facility like hospice, and they are bound by the HIPAA law and prohibited from disclosing even the identification of patients who may be there without the written consent of the patient. And I would not think harshly towards hospice. They are merely complying, in my judgment, appropriately complying with the requirements of HIPAA.
And it's a sad barrier, though, because it's going to block somebody from giving someone comfort. I think it's just the person was taken quickly and wasn't able to communicate with a friend.
Well, I understand, and the law isn't perfect, but they they draft legislation and pass laws to affect the general circumstances in general. And they basically rely upon the individual. If a person wants somebody to know where they are, then they have the right to give that information out, or delegate their family to give that information out, or to authorize hospice to give that information out. But absent that, the general law is to protect all persons, so they have to write it in a broad, they have to write it and apply it broadly. And it's unfortunate when a unique situation like that creates a hardship.
Right.
Yep.
All right.
All right.
Well,
thank you for calling in.
It.
Yes, I hope that helped.
Thank you.
We are. Thank you, Kathy. Appreciate the call. We are out of time, believe it or not. That was a very quick one, and I mean, I know it's the same length as always, but it just felt quicker than usual.
Well, we had a lot of good calls, and I want to say again, as I have many times, this show, whatever degree of success it may have, is due in large part much more to the wonderful listeners and callers that we have than anything that I do. We enjoy. The law is a fascinating profession, and we enjoy the opportunity to talk with our listeners about it and thank them for listening and calling.
Thank you. Maybe next week I can ask you about the guide you referenced earlier that kind of gives people an overview of like a way to choose an attorney. That's something I've always wondered about.
We'll be glad to talk about that.
Because you go to the Yellow Pages and it's hard to know.
Be happy to talk about that.
Thank you, John. What is your number?
Our office in Ocala is 352-547-4292. Our toll-free number is 855-534-2565. We have offices in Ocala and the Villages. If you have a legal problem that you think we can help you with, we'll be glad to talk with you.
And again, you can call us here at the radio station if you need those phone numbers repeated, or if you go to WOCA.com, Robin makes it easy. She puts John's information on the guest list every Wednesday, and you can find it there today. Just go to WOCA.com, go to the AM Ocala Live link, and you'll see John's name at the 1035 slot under Legally Yours. Good show, John. As always. We'll take a break and be right back.
Ocala's information station, 1370 WOCA.
Ocala.
ABC News Now. I'm Karen Chase. Parents and teachers awoke to the news that school was closed in Danvers, Massachusetts. They later found out it was because blood was found in a school bathroom, the body of a loved teacher was found in the woods, and a 14-year-old student was charged with her murder. A New Jersey woman has become the first in the state to be charged with vehicular homicide for causing a fatal crash while texting at the wheel. She could face 10 years in prison. Detroit city workers are fighting for their pensions in a trial that begins today. The city's emergency financial manager will face the city's creditors in a battle over bankruptcy protection and whether